this. Even though it transferred no power back to the courts. So the APA didn't transfer power back to the courts. Did not substantially increase judicial review. Still, nobody was making sure that we would have judicial review of our cases. That's why when I called Arizona, asked them about a judicial review, they act like they didn't know what it was. Continued the system of adjudication by those enjoying no life tenure. Now, what is this talking about? See, they're talking about the fact that they're not judges in the process of doing these transactions. So they're coming in, and an agency is allowing somebody who has no life tenure to come in for a little while, act like they're a judge, make a decision in your life, run away and go back to their normal job as a judge, and they make you think that they're judges, and they're not. That's why they don't have life tenures. None of your freaking juvenile court judges are there for life. In Arizona, they come in, they get rotated, and they leave out. They're making decisions by what the agency says, based on the report of the agency, like I just showed you, which shows that it's an administrative process and not a real court, and we were suffering through this in the 1930s. Watch this. And in general gave assurance that further efforts to cripple the power of the agencies would be unlikely to succeed. The battle over fundamentals had ceased. The federal administrative process seemed secure. Watch this. After the enactment of the APA, a period of relative tranquility set in. Judicial interpretations of the APA were generally sympathetic to its purposes, and the Act's middle position seemed to satisfy the formal partisans on both sides. The courts kept on grinding out refinements of the administrative law, both under the Act and apart from it. Okay? We're going to go down a little bit more. Watch this. In 1955 came the report of the President's Conference on Administrative Procedure, which had been appointed in 1953 to inquire into the narrow subject of unnecessary delay, expense, and volume of records in some adjudicatory and rule-making proceedings. The report was mild and helpful, and except, for the troublesome problem of status and hearing officers, mostly non-controversial. Okay, so we're going to look at a little bit more, then we're going to get in some fire. Okay,